In previous lessons, we explored ownership structures, survivorship rights, and probate processes in Arizona real estate. Understanding who owns property is only half of the picture. Knowing what claims or encumbrances exist against that property is equally vital. This brings us to the concept of liens, which are legal claims placed on property as security for a debt or obligation. A lien does not necessarily mean the owner has lost possession or ownership, but it does mean that the property cannot be sold, refinanced, or transferred with clear title until the lien is satisfied or released. A lien creates a connection between debt and property, giving the creditor a legal right to seek payment through the property's value. Under Arizona law, liens are governed primarily by ARS Title 33, which outlines the creation, enforcement, and priority of liens. The existence and priority of liens are critical in real estate transactions because they determine who gets paid first if a property is sold or foreclosed upon. Voluntary liens. A voluntary lien is one that a property owner willingly places on their property to secure a debt. The most common example is a mortgage or deed of trust. When a homeowner borrows money to purchase property, the lender requires a lien as collateral to ensure repayment. This lien gives the lender a right to foreclose if the borrower defaults. For example, if Emily buys a home in Phoenix and finances it through a bank loan, she signs a deed of trust that gives the bank a lien on the property. As long as Emily makes her payments, she retains full use of the home. However, if she defaults, the lender can enforce the lien through a trustee's sale under ARS, paragraph 33807, selling the property to recover the outstanding debt. Voluntary liens remain until the debt is paid in full. Once satisfied, the lender must record a deed of release and reconveyance for a deed of trust, or a satisfaction of mortgage to clear the lien from the property's title. Involuntary liens. Unlike voluntary liens, involuntary liens are imposed on property by law without the owner's consent. These liens arise when an owner owes a debt or obligation, and the creditor seeks to secure repayment through the property. Common types of involuntary liens in Arizona include judgment liens, mechanics liens, and property tax liens. A judgment lien is created when a court awards a monetary judgment against a person, and the creditor records that judgment with the county recorder's office under ARS, paragraph 33964. The recorded judgment becomes a lien on all real property owned by the debtor in that county. For example, if Mark loses a lawsuit and owes $50,000 in damages, the creditor can record a judgment lien, preventing Mark from selling or refinancing his property until the debt is paid or the lien expires. Judgment liens in Arizona generally last 10 years and may be renewed before expiration. Mechanics liens. A mechanics lien, governed by ARS, paragraph 33981 through paragraph 33 Wesson 8, protects contractors, subcontractors, laborers, and suppliers who perform work or provide materials to improve real property. This type of lien ensures that those who contribute to the value of property are paid for their services. To be valid, a mechanics lien must meet strict procedural requirements, including timely filing and notice. For example, suppose a homeowner in Mesa hires a contractor to remodel a kitchen, but fails to pay after completion. The contractor may file a mechanics lien within 120 days of project completion. If the homeowner still does not pay, the contractor may foreclose on the lien to recover the debt. This right ensures fair compensation for work performed and materials provided. However, mechanics liens can complicate real estate transactions because they attach directly to the property, not just the owner. A buyer who purchases property subject to an unresolved mechanics lien could become responsible for the debt. Therefore, escrow officers and title companies conduct thorough lien searches to ensure all such encumbrances are resolved before closing. Property tax liens. Property taxes create statutory liens on real property automatically each year under ARS, Paragraph 42, 153. If a property owner fails to pay their property taxes, the county treasurer may sell a tax lien certificate to investors. The purchaser of the tax lien certificate pays the delinquent taxes and earns interest until the owner redeems the property by paying the full amount owed, including penalties. If the property owner does not redeem the property within 3 years, the lien holder can apply for a treasurer's deed, effectively obtaining ownership of the property. For example, if Carlos owns land in Pinal County but neglects to pay property taxes for several years, the county may sell a tax lien certificate at auction. An investor buys the lien, and if Carlos fails to pay within the redemption period, that investor can foreclose on the lien and take title to the property. Property tax liens take priority over almost all other liens, including mortgages and judgments. Lien priority and foreclosure implications. Lien priority determines which lien holder gets paid first in the event of foreclosure or sale. Generally, Arizona follows the first in time, first in right rule, meaning the first lien recorded has priority. However, certain liens, such as property tax liens, always take superior priority regardless of recording date. For instance, if a property has both a mortgage lien and a mechanics lien, and the property is sold through foreclosure, the mortgage lender is paid first if their lien was recorded before the mechanics lien. Any remaining proceeds go to subsequent lien holders in order of priority. If sale proceeds are insufficient, junior lien holders may lose their right to collect. Practical example. Consider a homeowner, Lisa, who owns a property in Gilbert. She has a mortgage with a bank, owes unpaid property taxes, and recently failed to pay a roofing contractor. The county files a tax lien, the contractor files a mechanics lien, and the bank holds a voluntary lien through the deed of trust. If Lisa defaults, the county's tax lien takes first priority, followed by the bank's lien, then the contractor's lien. Understanding this hierarchy ensures all parties know their rights and risks in recovering debts. Case example, Lewis vs. Midway, Lumber Inc. Cupboard, 1972. In this Arizona case, the court reaffirmed that mechanics liens are designed to protect those who enhance a property's value. However, strict compliance with statutory filing deadlines is required. Otherwise, the lien may be invalid. The case emphasized the importance of timely recording and notice in enforcing lien rights. Discussion. Why is it important for real estate professionals to verify the existence of liens before closing a transaction? Answer. Because unresolved liens can cloud title, delay closing, and transfer financial liability to the new owner if not satisfied before conveyance. What distinguishes a voluntary lien from an involuntary lien? Answer. A voluntary lien is willingly placed by the owner, such as a mortgage, while an involuntary lien is imposed by law without consent, such as a judgment or tax lien. Why do property tax liens have priority over all other liens? Answer. Because they are statutory obligations tied to the government's authority to collect taxes, ensuring public revenue takes precedence over private debts. Review summary. Liens are essential legal instruments that secure debts and protect creditors by attaching to property. Arizona law recognizes both voluntary liens, such as mortgages and deeds of trust, and involuntary liens, such as judgment, mechanics, and property tax liens. Each type carries specific legal implications, filing requirements, and enforcement rights under ARS, Title 33 and Title 42. Lien priority determines the order of payment in foreclosure, with property tax liens holding the highest rank. For real estate professionals, identifying and resolving liens before closing ensures that buyers receive clear, marketable title and that transactions comply with Arizona law.